All right, welcome, future barristers. We're about to dive into some of the most crucial and, let's be honest, often overlooked sections of the Queensland Evidence Act. These miscellaneous sections, they're an absolute goldmine for exam questions, so mastering them is going to give you a serious edge.
So, are you ready to get into it? We're going to tear through this and turn what looks like dry, textbook jargon into a clear, strategic weapon you can take with you into that evidence exam. Let's do it. Okay, here's how we're going to tackle this. First, we'll talk about the people, who gets to speak in court. Then we'll get into the really juicy stuff, the rules around evidence. After that, we'll look at procedure, and we'll finish up with some key court powers and a few little quirks of the act. Right, part one. Let's start with the absolute fundamentals, the rules that govern the actual human beings who give evidence in a trial. First up, Section 131. Now, this seems incredibly obvious today, but it's a fundamental rule of fairness. Defense witnesses have to be sworn in, just like prosecution witnesses. Believe it or not, this rule actually fixed a historical imbalance that goes all the way back to 1702. It puts everyone on a level playing field. So what happens if someone can't be understood? Well, that's where Section 131A comes in. It gives the court the power to get an interpreter. And look, this is more than just a procedural box to tick. It's about fundamental access to justice. For your exam, remember the key phrase, the court will order one when the interests of justice require it. Okay, now for a section you absolutely have to get your head around, Section 132A. This is a real beast. It's complex, it's highly examinable, and it deals with one of the most powerful and, frankly, most prejudicial types of evidence out there, similar facts. So here's the core problem, right? When is it fair to use someone's past actions against them in a current case? It's this incredible tightrope walk between the value of that evidence and the huge risk of unfair prejudice. The law has wrestled with this for a long, long time. And to understand the rule we have now, you've really got to see how we got here. For ages, the common law was super strict. Then, in 1998, the High Court, in a case called Hoch, laid down a very specific rule. But, and this is the key part, Parliament came in over the top in 1997 and basically said, no, we're doing it this way, and gave us Section 132A. And here is the absolute game changer. Under the old Hoch rule, if there was even a reasonable chance the witnesses had cooked up their stories together, collusion, the evidence was out. The judge had to throw it out. Section 132A completely flips this on its head. Now, the possibility of collusion doesn't automatically kill the evidence. It becomes a question of weight for the jury to figure out. So the bottom line is this. The judge's job is now to do a balancing act. Is this evidence more valuable, more probative, than it is unfairly prejudicial? If it is, it goes to the jury. And it's the jury, not the judge, who decides if the witnesses are believable or if they've colluded. That power has shifted. Okay, let's switch gears a little. We're moving on to a couple of procedural sections that can have a massive impact on the fairness of a trial and, ultimately, on the sentence. Now listen up, because Section 132BA is a classic exam question waiting to happen. It sets out a very specific three-step recipe for judges when a long delay might have hurt the defense case. Step 1, identify a significant forensic disadvantage. Step 2, tell the jury about it. But Step 3 is the crucial part to remember. The judge is explicitly forbidden from using certain words. They can't say it's unsafe to convict, or tell the jury to scrutinize the evidence with great care. The wording of the direction is very, very specific. All right, moving on to sentencing. Section 132C tells us the standard of proof for any disputed facts. And it's not the criminal standard, beyond a reasonable doubt. No, it's the civil standard you see here, on the balance of probabilities. And this was put into the Act specifically to reverse a court decision that tried to use the higher standard. But, and this is a beautiful, nuanced bit of law, it's not quite that simple. Section 132C also writes the bridge and job principle into the law. What does that mean? It means that even though the standard is the balance of probabilities, the more serious the allegation is and the bigger the consequences for the person being sentenced, the more satisfied the judge has to be before they can say it's proven. It's like a sliding scale of proof. Okay, we're on the home stretch now. Let's finish up with a key power the court has over documents and a funny little legislative curiosity that I guarantee you will remember. So, Section 133. This gives the court the power to impound a document. What does that actually mean? It just means the court can grab a document and hold on to it to keep it safe. It's a really practical tool, and it applies to any document shown to the court, even if it doesn't end up being admitted into evidence. A great example is if a document reveals some kind of tax fraud, the judge can impound it to make sure it gets investigated.
And now, for our grand finale, let's talk about a legal ghost that still haunts the pages of the Evidence Act.
You're seeing that correctly. The Evidence Act still has a rule about something called breach of promise of marriage. The only problem, that entire cause of action was abolished way back in 1976. As the commentary so brilliantly puts it, its only relevance today is in a Gilbert and Sullivan operetta. It's a great bit of legal trivia and a perfect reminder that the law doesn't always clean up after itself. Okay, let's boil this all down for your exam notes. Here are the key takeaways. 1. Witnesses are sworn in, and interpreters are there for the interests of justice. 2. Under 132A, for similar facts, collusion is a question of weight for the jury. 3. For sentencing under 132C, it's the civil standard with that Briginshaw flexibility. And 4. For delay, you have to know that strict formula in 132BA. Got it?
And that really leaves us with one final thought. All of these seemingly random rules, from old-school oaths to modern sentencing principles, they're all part of the same delicate balancing act, an act between the timeless search for truth and the absolute necessity of a fair trial. If you can master these sections, you are one massive step closer to the bar.